Welcome to episode 15 in the first season of Justice Center Weekly, the videocast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and today our guest is Saskatchewan lawyer Andre Mamare, who is joining us to talk about the case of a nurse in his province, Leah McInnes, who is facing disciplinary action from the Saskatchewan Registered Nursing Association over social media posts she made challenging vaccine mandates, vaccine passports, and privacy invasions. Andre, what stage are we at with this case?
Hi, Kevin. We're currently just at the stage of preparing for a hearing. We're anticipating the hearing of this disciplinary matter to proceed this fall.
Okay. And you don't have a specific date, though, yet. That gets set right away? Is that coming up? The dates?
We currently have a date, but due to certain complexities with the case, our anticipation is that date will be adjusted to likely November or perhaps December, and we're anticipating it to proceed at that time.
Okay. Just before you lay out some of the facts for us, maybe I could ask you, this is a free speech case, isn't it?
That's correct. This is entirely a case about freedom of expression, and it's really testing, once again, I may add, a nurse's right to freely speak about healthcare matters. As you may recall, the issue of a nurse speaking freely and openly about healthcare matters was a topic of great interest. In fact, there was a case called Strum that had proceeded all the way to the Court of Appeal, and a decision was rendered in 2020 with respect to freedom of expression of a nurse who had openly criticized the healthcare system. And it looks like we're headed in that direction again with respect to our nurse client in this circumstance. But the law was authoritatively established in Strum, and in our views is quite instructive as to the right of our client to express herself on these very important matters.
Okay. Maybe just lay out the facts briefly for us. I mean, I gave you a little bit of an idea, but just fill it out for us a bit.
Certainly. So this is primarily a case involving Leah, who had, firstly, in September of 2021, she had attended a protest outside a hospital in Saskatchewan. She was carrying a sign that said RN against mandates and vaccine passports. And she had taken to social media and expressed her opinion about a number of things that was quite commonplace amongst the discourse online. She had discussed issues regarding the damage being done as a result of medical coercion that a lot of people had expressed concern about. She implored people to write to their MLAs. She expressed a sentiment of a sentiment that what was happening was wrong and unethical. She in fact supported vaccination. In this particular case, she had actually expressly supported vaccination, but was concerned about the lack of choice due to the threat of loss of jobs that was happening, or access to amenities that we were seeing commonplace for those that were unvaccinated. And she also made comments about sterile immunity and COVID-19 vaccines and how they're different than other vaccines that people would not otherwise may not otherwise be aware of. She had expressed some concerns about transmissibility at that time, as there was some evidence emerging with respect to transmissibility concerns as to whether the vaccine was effective with respect to reducing transmission. Interestingly enough, in fact, the Premier of Saskatchewan, Scott Moe himself, had actually openly indicated at one point later on that the vaccine was not effective at reducing transmission. There were other comments that she made with respect to the viral loads of persons who were vaccinated and unvaccinated, and transmissibility issues with respect to that, and she also made other social concern type of comments with respect to the mandates really causing a lot of division, and how there was a political aspect to the mandates, and how there were nursing shortages, and that the mandates would have a negative impact, and that is with respect to mandates on healthcare workers, that if they were implemented, that they would have a negative impact on the healthcare system that was strained at the time. She also, as you pointed out, made some comments about concerns around privacy of information, and she generally spoke out against coercion and threats and manipulation and ultimatums and shaming that was taking place by, well, we saw certainly that there was some shaming by the media, and others, with respect to those who had chosen not to vaccinate. Interestingly enough, on that note, with respect to all of this political pressure, I understand very recently, actually, it's become public that the government of Saskatchewan had hired Brown Communications Group, which was an advertising company that has openly indicated that they engaged in sort of a fear tactic policy of creating advertisements for the government of Saskatchewan to push people to vaccinate, rather than to inform the public of benefits and risks, and give them the opportunity to choose for themselves as to the medical decisions that would be appropriate for their health. The government had hired a private advertising company that thought it would be appropriate to engage in fear tactics. In fact, I quote, the company had indicated that they strategized, that if someone's vaccination status, that if they weren't vaccinated, that it would impact their social life, their travel plans, and entertainment, and really just to create this sort of fear that you're missing out on life, and you're kind of a loser, really, if you're not engaging in what the government thinks you should engage in. And so she spoke out. She didn't specifically speak out about that, but now we're seeing a tremendous amount of uh, facts emerge from that time as to what was occurring. Now, she did speak out with respect to some of these measures that had been implemented. They were, in fact, unprecedented. Of course, we'd never seen government measures being implemented to this degree. And she commented about, as to what it would have been like if the government had not resorted to these types of measures that she interpreted as having a negative impact on society. And of course, we're well aware of other societies around the world, particularly in the Scandinavian nations, that did not actually implement a number of these types of measures. And so we have now the benefit, in hindsight, to examine these sort of issues. And so she was really doing sort of a call as to there's got to be essentially a better way. Um, and so anyway, she really expressed a sentiment of compassion that you would really expect from a healthcare worker. That a healthcare worker would be apprised as to what's going on, and really critically think things through, and have a level of compassion for those in society, and harms that may really come about as a result of these types of measures.
Okay, yeah, I was looking at the complaint that was filed, the appendix in there, and they say that when they're referring to her posts on social media, they said she was posting disinformation, quote, disinformation and or misleading information surrounding vaccine mandates and vaccine passports, and therefore failed to comply with the code of ethics of the association, unquote. Does that mean you are going to be litigating the facts? Are they going to be litigating the facts? Are we going to be looking at just a straight ahead free speech case? Are we going to be throwing what she said up onto a big screen and examining what has happened subsequent to her comments?
Well, it's a fair enough question. I don't really want to dive into it too deep into the details at this stage. Of course, we've got the hearing coming
Okay.
up. But with respect to the allegations, of course, as you would have noted in the notice of hearing, their position is that essentially Leah is engaged in professional misconduct and/or incompetence in violation of the act. And the basis by which they rely on this is that, as you put it, that she's spreading disinformation, misinformation. It's interesting. A case out of Ontario had criticized those very terms. These are largely new terms that have entered the fora. But with respect to those allegations, and of course they're in a position of having to establish that the case against her that they've alleged. And so we look forward to defending her with respect to the comments that she's made.
Yeah, well, that's why I was wondering whether they actually have to get up and prove that everything that she said is wrong. I guess that's essentially what, if they're going to categorize things as uh, misinformation or misleading information, I guess that means that they're going to. Is the onus on them to prove that what she said is wrong? That's what I'm
Uh,
wondering.
Certainly, I mean, they're the ones making the allegation that what she said is misinformation. So they will have to establish that what she has said is in fact false. And so, again, we look forward to that.
Okay.
And so it's interesting because the case really essentially is really about the code of ethics, the bylaws, and the act, and it's the interplay of a nurse's obligations with respect to these pieces of policies and essentially regulation that she's got to abide by. And it's interesting because if you examine them, and and I can briefly give you an idea of the types of things that are in the practice standards and and the code of ethics. The practice standards are in fact
Yeah, sure.
in Okay. The practice standards are in fact incorporated into the bylaws and they're applicable in this situation. And one of the practice standards, just by way of example, Section 17, it essentially imposes a requirement for nurses to advocate and intervene and participate with others as needed for to enhance client safety. Um, by way of more examples, Section 214, it's really about having a knowledge based practice, and nurses are required to have knowledge from nursing and other disciplines and to be apprised of current and emerging health issues, not to simply toe the line as to what they're told. They're required to have some knowledge and to really examine things and really look into emerging health issues. I want to give you three more examples, and these are just some highlights from the practice standards I think are just important principles. And quite frankly, these are really good principles to have. The Section 217, for instance, it requires a nurse to anticipate potential health issues and not to simply blindly um, um, you know, uh, charge forward without having any sort of anticipatory ideas as to what could uh, occur that would be deleterious to health. Section 218 requires that they look at new information with a critical inquiry. Having a critical mind and examining these issues is part of a nurse's duty, and to, of course, advocate for the best interests of clients. And those are just some practice standards that help guide some of our examination as to a nurse's obligations. And the code of ethics, if you want, I can turn some attention to the code of ethics as well. Um,
Yeah, actually, I'm just looking at some of the things that are cited in this notice of hearing, which is in the appendix that they lay out the complaint. And one of them is C, promoting and respecting informed decision making. I sounds very much like this is what she was doing to me. But anyway, you can lay that out for us.
well, that's indeed one of them. Part 1 C4 actually imposes on nurses to be sensitive to the inherent differentials between care providers
Right.
and persons that are receiving care, that they don't misuse or abuse that power to influence the decision making of patients. And so we see the interplay of that relationship being paramount with respect to medical decisions, including vaccination, where I think just recently it's been identified that, and I hope I'm not incorrect about this, but uh, my understanding is that physicians were awarded a certain fee for vaccinating a client, and so there was sort of an interest in order to do so. Now that doesn't necessarily mean that every physician would have undermined their obligations, but you see there's a power imbalance here. There's the physician or the nurse who has the knowledge and the expertise, as well as the access to all of the information, as well as the resources in that situation, and then there's the patient who really relies on the medical professionals in order to genuinely guide them in making a decision, and not seek to try to influence the outcome of their decision, but rather simply just to give them that informed information so that they could make a decision that's really good for them. Um, there are some other interesting parts of the code of ethics that are instructive. Just by way of example, part 1 F8 requires nurses to work collaboratively to develop a moral community. And a part of this is that they must acknowledge their responsibility to contribute to positive and healthy practice environments and support a climate of trust that sponsors openness, encourages the act of questioning the status quo, and supports those who speak out, in fact, in good faith to address concerns. In fact, the Code of Ethics identifies explicitly, by way of example, whistleblowers. And it explicitly indicate nurses protect whistleblowers who have provided reasonable grounds for their concerns. There's supposed to be a climate of openness. There's supposed to be a protection of whistleblowers. There's supposed to be, as long as they're genuinely held beliefs, and that those beliefs are held in good faith. The code of ethics is actually sets out to protect those like Leah who had genuine beliefs and in good faith express their opinions. And there's a number of other sections of the code of ethics, as well as the practice standards, that are very instructive. But those are just some of them. I just want to leave you with perhaps another one, which is recognizing that vulnerable groups in society are systemically disadvantaged, which leads to diminished health and well-being, and advocating to improve their quality of life while taking action to overcome barriers to healthcare. I can think of a number of examples where this is becoming increasingly a concern. Although I'm not familiar with a particular case in Saskatchewan, we've recently come to know of an individual in Ontario who was denied a transplant as a result of his decision not to vaccinate, and so he was in this disadvantaged group, and there's a barrier to his ability to receive much needed life saving treatment. And really, in that scenario, and these code of ethics, by the way, are national. They've been adopted by Saskatchewan. These are the Canadian Nurses Code of Ethics. You would imagine in that situation, there's a prescriptive obligation on healthcare workers, particularly nurses in this situation, to sort of advocate against that very, very unfortunate outcome. And of course, with the case of Annette Lewis, which we've all become very familiar with, a very similar scenario where a barrier to life-saving treatment was implemented, and that is really the basis behind these ethical codes, to not only prescriptively obligate healthcare professionals, in this case nurses, to speak out and to do something and to proactively inform others and blow the whistle as to these anticipatory healthcare outcomes and issues. But it's also intended to protect them in the process of doing so. And in this case, unfortunately, it appears that the regulator, rather than to um, uh, so it seems, rather than to protect her, rather than to examine her genuine held beliefs and in the good faith that she uh, spoke out, they're prosecuting her. And unfortunately, we've seen this before by this very regulator, all the way to the Court of Appeal. And so it's unfortunate we're in this situation again, only 3 years later. And in fact, um, I would love to share a quote from Strum that I think is especially instructive and important, especially in these times. And our Court of Appeal has been um, very gratuitous in their explanation as to these important principles, and particularly at paragraph 160 of that decision. I quote: the court states, "The freedom to criticize services extends equally to public services. Indeed, the right to criticize public services is an essential aspect of the linchpin connection between freedom of expression and democracy. In Canada, public healthcare is both a source of pride and a political preoccupation. It is a frequent subject of public discourse, engaging in the political class, journalists, medical professionals, academics, and the general public. Criticism of the healthcare system is manifestly in the public interest. Such criticism, even by those delivering those services, does not necessarily undermine public confidence in healthcare workers or the healthcare system. Indeed, it can enhance confidence by demonstrating that those with the greatest knowledge of this massive and opaque system and who have the ability to affect change are both prepared and permitted to speak and pursue positive change. In any event, the fact that public confidence in aspects of the healthcare system may suffer as a result of fair criticism can itself result in positive change. Such is the messy business of democracy. End quote. And I think that
Well, actually,
paragraph.
that I was going to say that kind of hits on the point that I wanted to get when referring back to Strom, because I remember that case, and that nurse was criticizing the system itself, that is like the public health system, whereas it seems in these tweets and social media posts, at least the summary that I'm reading of them, it seems like it's more a question of policy and politics. So I was wondering about the analogy between the two cases. Is it? It sounds like, based on what you just quoted there, they are analogous.
I think they're absolutely analogous. I mean, she's criticizing aspects of the healthcare system, which includes policies that are a part of the healthcare system. And who better than healthcare workers within the system criticizing it? Now, we have to appreciate that criticism by the public is something that the public must see that the regulator openly permits criticism, even whether or not that criticism ends up at some point in time being true or not. The permission to permit her and people like her to speak openly, as long as it's genuine and in good faith and is not entirely unreasonable. Her ability to speak is an important aspect of the confidence for the healthcare system itself. If the public is of the view that the regulator does not permit or censors or prosecutes those who genuinely and in good faith speak out as to concerns that they're seeing, um, that is what leads to a loss of trust and confidence in the healthcare system. So I think we're very lucky because here in Saskatchewan, this isn't just a precedent, an old precedent or from another province. This is our highest court 2 years ago, authoritatively laying down the law about this really a very similar issue. So the hope is that um, these legal principles apply in this instance. In fact, it's more than a hope; it's the law. It does apply, and so the hope is that the decision makers in this case are genuinely open to the facts and open to what has occurred here and apply the law correctly.
Who are the decision makers in this case, and what possible sanctions does your client face from these people?
Right. Well, the decision makers are, by virtue of the act, they're comprised of registered nurses. I believe in this case, and going off memory, I believe there's three registered nurses. There's also a member of the public who is to comprise of the hearing panel.
Okay, so we've got a panel, but getting to the sanctions, they can apply sanctions. Can they take her job away or strip her professional accreditation? What can they do?
Oh, absolutely. The panel has a wide toolkit as to the sanctions that they could impose on her. They could strike her right off the list and take her license away, which would be the most extreme outcome. They can suspend her. They can require her to virtually, do anything in terms of take courses or face some level of penalization. I think in front of you, you'll note the notice of hearing itself lays out just how wide the scope as to the outcome could be, anywhere from requiring her to virtually do any sort of a remedial act to losing her license entirely and being struck from the record.
And as far as her options, if they convict her, her options, she can move this over to a regular court in an appeals. Can she do it that way, or?
Yeah, well, that's right. That's actually the path that Ms. Strum uh, faced. In fact, Ms. Strum had lost at the disciplinary stage. She commenced a judicial review application to the King's Bench Court. At the time, it was the Queen's Bench Court, and actually lost at that stage of the proceedings as well. And then it was not until our highest court examined the entirety of the record and laid down the decision that they did in 2020. And so hopefully that's not the path that Leah's on. And our hope is that because we have the authority of our Court of Appeal and the benefit of the legal principles that were established there, together with the Act as well as the Code of Ethics, Practice Standards, and Bylaws, which in our view merit this matter to have never even have been commenced, quite frankly, and should have been immediately struck and dismissed. Unfortunately, it has proceeded to the disciplinary stage, and with some good examination of the facts and the evidence and the law, it is hoped that the panel will dismiss this case at that stage.
Great. Well, here's hoping. And thanks, Andre, for appearing on our Justice Center Weekly episode. I had a good time talking to you again. Been a long time, and I hope to speak to you again sooner.
That sounds great, Kevin. Good to be with you, and looking forward to the next round.